In this video, we're going to be talking about filing for emergency custody in Indiana. Sometimes you may have an existing divorce or custody case and you may have parenting time orders in place, but something happens that justifies an immediate change or causes concern about the child's safety. We're going to talk about what to do in that situation. So about me, my name's Nathan Vining. I'm a family law attorney here in Indiana, and hopefully by the end of this video, you know more about what constitutes an emergency where you can file for custody and what you can do if you find yourself in that situation. When looking at emergency custody, the real thing you're looking at is the child's well-being, whether that be physical well-being, mental well-being. Ultimately, an emergency custody really comes into play where that child's safety is at risk. And another big thing with emergency custody is should you involve law enforcement or DCS. And if you have an attorney, definitely call your attorney, but DCS has people on the ground who can get out and respond to an active situation and remove a child if there's an emergency. Law enforcement is also appropriate to call in these situations. So if you find yourself dealing with an emergency situation, definitely do not hesitate to call the police or DCS if that's appropriate for your situation. The process for filing for emergency custody is similar to filing for a standard custody modification. It oftentimes just includes an additional motion, which is an emergency request for a hearing. And ultimately, in that motion, what you're going to do is provide specifics on what led to the emergency situation, explain the risk of the danger to the children, explain how if the court doesn't take immediate action, that there could be consequences, explain the need for the court to take immediate action, and then request what exactly you're looking for the court to do, whether that be make some simple modifications to the parenting schedule or even go as far as requiring supervised parenting time for the other parent. So what is an emergency situation? Ultimately, it can vary case, but a lot of times it will involve the police and arrest, substance abuse issues, or potential family or domestic violence. And here's just some examples. The custodial parent or non-custodial parent may be arrested for a violent crime that gives you cause for concern about the children in their care, or there may have been an arrest where they were around and then potentially there's no children. Another thing is that if DCS has been involved and they've done an investigation, maybe they uncovered some things that caused you concern that make you want to file for an emergency modification. Or potentially there could be things going on in the other parent's home that causes you concern about their immediate safety. That can be a variety of factors, or even the children's own action could cause you concern. It could be a lack of supervision in the non-custodial parents or something like that. But ultimately, it varies case by case. But if you believe that the children's safety is at issue, you would want to move. With emergency custody issues, it's also important to understand the kind of evidence you need. A lot of times people will come to me with evidence that's here. For instance, you can't go into court and tell you what your child told you. You're going to need to get additional evidence about what is occurring, and that can be stuff through certified court. It could also be potentially having the child talk to a therapist and disclose what may be occurring with the other parent. There's a lot of ways you can get around hearsay or get hearsay evidence in, but you're going to need to work with an attorney to make sure that if you file for an emergency custody, you actually can back evidence that is allowable. The other thing is you should also know what to expect. In emergency custody, it's very similar to filing to modify custody, but when you request that emergency hearing, typically you're going to see a hearing set within 30 days, often faster. Another thing that may surprise people is that it's oftentimes a very quick hearing. It can sometimes be 15 to 30 minutes, maybe an hour maximum. So when you have that limited time in court, you may be limited with what evidence you can present, so you have to really be narrow about what issues you're bringing to the court and really keep it tailored to what the emergency is, so you actually can get through the hearing within the time allotted. So you're going to want to have a good strategy in terms of preparation, in terms of how you approach this the most efficient way possible so you get things done. It's also important to know that the standard for modification is still the same. In Indiana, when you file for emergency custody, it's the same as if you filed a modified custody. You're going to have to prove that a modification would be in the best interest of the child. And I have a couple other videos that talk about this, but there's essentially several factors that the court would look to when they're looking at the best interest of the child. And that can be things like the mental and physical health of the parties, the child adjustment to their home and community, as well as family or domestic violence. And those are kind of the three biggest areas where I would see emergency issues arising, whether that be substance abuse issues in the child's home environment, or maybe even patterns of family or domestic violence that are causing you concern for the child's safety. So you're going to want to build your case at the same you would in a custody case around those best interest factors to show why a change would be in the child's best interest. So ultimately, if you're dealing with a custody case and you have questions and you're dealing with an emergency situation and you need help, feel free to give me a call or text me. I'd be happy to walk you through a situation that may be going on in your life right now.